Good evening, everybody, and welcome to another edition of the South Florida Tribune Podcast. Yes, you've got the three-man booth. The man in the tie is Joe Littman, and the guy with the big beard, the brown beard, is Ron Renzy. These are my co-hosts. We do this every Tuesday night. Welcome back to the big show with the big three. No, I don't mean I don't mean Ford, Chrysler, and GM. I'm talking about Scott, Joe, and Ron. Here we are, guys. How about
Hello, everybody.
Hello, Ron.
Hello, Scott. Hello, John. Hello, Joe.
Yeah, see, now Ron's getting into that John thing.
See?
Like I did when I
It's Scott's fault.
It's contagious. It's contagious stuff. Energy, enthusiasm, fun is contagious. And what we're going to do every Tuesday night here in the South Florida Tribune Podcast, I want to make sure that our energy is contagious to you. And I can guarantee you right now, whether you like the pun or not, you won't need a vaccine for this one. You just better make sure that you don't turn red and laugh with all the one-liners. We're going to incorporate with all the seriousness that we're going to make sure that everybody can laugh and learn. But that said, Joe Littman, since we have a lot of baseball going on and the Marlins start their playoff series against the Chicago Cubs, it's only appropriate that I let Joe Littman lead it off. Go ahead, Joe.
Okay, thanks, Scott.
You're welcome.
So this is our second podcast in a multi-part series about property damage claims, and the Nor Law Group is a Coral Springs law firm that specializes in property damage claims. We handle claims all over the state of Florida for commercial and commercial property owners and homeowners if they have damage such as windstorm, hurricane, tornado, fire, water damage, what have you. So last week we talked about what to do in preparation for a storm or any sort of loss in general. Make sure that your policy is got the right coverage, things like that. When it's a good idea to hire an attorney to help you handle a claim. And today we're going to talk about the litigation process. And so what we're talking about today is what happens when all efforts to resolve your claim with the insurance company break down. They've either denied your claim and won't reconsider the denial. They have underpaid it and won't pay out any more after you've asked them to reconsider, or they're just delaying your claim and they just won't get back to you. And more than 90 days have gone by and they haven't given you an answer. And I say 90 days because there's a statute that gives them 90 days to make a decision on a claim, whether to deny or pay. So you've gotten that far, and either with the help of a public adjuster or on your own, you've just come to a brick wall, an impasse with your insurance company. So that's when a law firm such as the Nor Law Group can help you file a lawsuit against your insurance company. The first part of the litigation process is when the person who is making the complaint, called the plaintiff, files a complaint and a summons on what's called the defendant. In this case would be your insurance company. And the complaint contains all of the things that you're alleging that they didn't do properly. In this case, it's a breach of contract because your insurance policy is a contract. And what the complaint would allege in a property damage claim is that the insurance company breached the contract by either denying a claim or not paying the proper amount of the claim, or both, because maybe they denied some of it, paid part of it. Once the insurance company is served with what's called the summons, it's when electronically they get an electronic copy of that complaint delivered to them by the state of Florida Department of Insurance. They have a certain number of days to file a response. They have 20 days, but it's not uncommon for them to get an extension of time to respond. Now, they could file an answer, or they could move to dismiss the complaint, which is not uncommon. It's a litigation tactic. And the first thing you need to know when you get in this litigation process is it sometimes doesn't happen so quickly. You file the complaint, you might read the rules yourself and see they have 20 days to respond, but but that rarely, if ever, happens. And filing a motion to dismiss means that they get to set that for hearing. That could be a month down the road, 2 months down the road, and then only until that gets ruled on by the court do they have to actually file a formal response, like an answer. And the answer is the document that is filed by the defendant, in this case the insurance company, which admits or denies the allegations of the complaint, and that's where they get to put any defenses in there. And in the insurance setting, for a property damage case, typical defenses are you didn't give a proper notice and of the loss. You waited too long, and we've been prejudiced by that. Or you didn't safeguard your property, or your damages are due to wear and tear. Your roof is old. A lot of things I had discussed last week in your duties to comply with the contract. If you didn't comply with your duties under the policy, this is where the insurance company asserts those as defenses to your complaint. And if there's something that they could, some claim that they have against you, which is not common, but they could file a counterclaim along with their answer. Again, that's not very common. And another thing that's also not common is if the defendant fails to answer the complaint timely, the plaintiff could get what's called a default judgment. But in an insurance setting, that's never going to happen, because these are big companies that aren't going to let things fall through the crack. Even if they did let it fall through the crack, the court's going to let them file an answer, and even if there's a default, they're going to let the court, they're going to let the insurance company get out of that default. So that's the initial stages of a lawsuit. Have any questions so far?
No, I'm following along with you.
Okay, so that's the pleadings stage of the complaint, and when I say the pleading stage, the discovery stage comes next. But in my experience, in experience, I think of most plaintiff's attorneys for property damage claims, the discovery phase overlaps the pleading stage. And what discovery is the process of gathering documents and information. The parties gather that from each other. And what we'll do when we file a complaint is, at the same time, we'll send what are called interrogatories, which are written questions, and request to produce, which is a written request for documents and information, and a request for admissions, which is a document that asks the other party to admit certain things as a fact or deny them. Like, for instance, example of a request for admission would be admit that there was a valid policy between the plaintiff and the defendant. Admit that on such and such date there was damage to the property. That's a lot of things that you allege in the complaint that they have to answer would be the subject of a request for admissions. And if they have to say yes, we admit that, or no, we deny that, and then it kind of narrows down the issues in the case so that you can focus on what's in dispute. Although, generally speaking, the defendant denies just about everything and says, I'm going to make you prove that. So again, in our experience, we filed discovery along with a complaint. Usually the other side gets 30 days to respond, but when you file it with a complaint, they get 45 days. And again, it's fairly customary for the insurance companies in these litigations to ask for an extension of time, and any court is going to grant them. So if you're involved in litigation, you see your attorney is agreeing to giving the insurance company more time to respond to things, don't get upset. It's what every attorney would do, because I'll tell you right now, if you object to it, all that's going to happen is you're going to go to a hearing. It's going to take longer in the long run to contest it. You're probably going to upset the court for denying it in the first place, or not agreeing to it in the first place. So I think, Ron would agree that I like to
Absolutely.
try to get along with my opposing counsel. The goal in this is to try to come to a resolution of your claim, and you start stepping on toes from the outset. I mean, you be aggressive when you need to be, and if it's warranted. But just to start off that way for no reason doesn't really serve anybody's purposes. So, and another thing that people have to understand when they get in this process, it doesn't have to be a long process. We've had cases recently that we've just filed, and the insurance company's attorneys came back and said, "Hey, give us a demand. We'll try to settle this." We gave them a number. They came back with a very close number, and we got resolved within less than a month. That's not typical. It doesn't happen a lot, but it really depends. It really depends on the attorney you have on the other side and the insurance company, and a lot of times just the particular adjuster that's assigned to the case. Sometimes when you get a bad combination of an insurance company and their defense counsel and an adjuster that's just not amenable to settling, or they just are so inundated with claims that they haven't even taken a look at your case. Things could take longer, and when you get in this process, you just have to be patient, because it's not a quick process. You have to know that you might be in for the long haul. It might take a year, maybe 2 years to resolve a case, depending on.
I will say one thing, having been in a personal injury situation myself, you're right. I mean, these are things where you can either resolve them with a reasonable offer, or if they're willing to stand this thing out and turn it into a first-class marathon.
Yeah.
Then you have to be equipped to go either way, depending on the counsel, the judge, and all the intangibles that are working with you. And I can tell you right now, I had a personal injury case that lasted the better part of 10 years.
Oh, wow.
Yeah, it did, but I wasn't about to back down. But I had one little ace in my pocket to help get it resolved. When I knew we were getting to the nitty-gritty, I told my attorney that if these guys don't go ahead and straighten this thing out, I'll do something that Don King did when he had trying to get George Foreman and Muhammad Ali together. That I'll go ahead and bluff my way into a settlement or make a chess move on the table. Oh, I've already got it set up that I could blow you away in the media. And then what people will realize is media pressure at one time tends to make you think a little bit, especially in the day where you have Google and all kinds of things out on a news cycle that goes by the 10th of a second.
Yeah.
So how much does some of that come into play? Do a lot of these cases worry about public pressure, media involvement, that it could make things a little bit more difficult for them, or do they just go through the process and just hope for the best?
I don't know if they're too concerned. I think the most that they would be concerned with is not going to a jury trial. For instance, we have cases that are up in the Panhandle from Hurricane Michael, where people just lost everything. And I've gone to some mediations in those cases, and the mediator from that area straight out said, "Look, not to me, but to the defense counsel, you don't want to take this case to trial, because people in this county are not going to be sympathetic to insurance companies that are denying or underpaying claims." And I think to a large part, the insurance companies heed that. And I'll have to say that sometimes it takes a while to get done, but they eventually do settle. I mean, the vast majority, 99.99 in my experience of our cases, settle by way of either a informal settlement discussions between the attorneys for the plaintiff and the insurance company, or by mediation. And I'll get to that in a moment, the mediation process. That can happen anytime, but usually happens during the discovery or following the discovery phase. I can tell you our firm's practice and our preference is we try to resolve these things as quick as possible. So as soon as we file a claim, we're giving a demand for the insurance company of what our client is owed to restore their property to its pre-loss condition. That's the goal, is get the amounts that they need to do all the repairs they need to make their property just the way it was before the loss happened, minus whatever the deductible is. Obviously, you can't recover the full amount, because every policy has a deductible. And sometimes, for I don't know if most people know this, but for hurricanes, the deductible is generally a lot larger than their deductible that would be for a water loss, for instance. It's not uncommon for a deductible for any particular loss to be $1,000, $2,000, but your hurricane deductible, which is a percentage of your policy, could be 8, 10, or more. Depend. Like I think I told you last week, there was one I saw that it wasn't the usual 2% or 5%. It was like 10% of the policy. It was an enormous deductible. So that gets back to make sure you know what your policy is, because you don't want to be in for that shock when you're making a claim, because you almost have to have a catastrophic loss for you to meet that threshold. But anyway, so most of these cases do eventually wind up getting settled either through mediation or through settlement discussions between the parties' counsel. And truth be told, eventually you're going to have to do that anyway. Before your case would ever go to trial, a judge would make you go to mediation. So our preference is always to go to an early mediation rather than later. And it's a balancing act, because you want to have enough information before you go to a mediation so that you know what the strengths and weaknesses of the other side's case and your case are. But you don't want to rack up a whole bunch of attorney's fees so that those fees are a barrier to settling. So, in my experience, we go to mediation fairly early on in the case, and sometimes the court will make you go to mediation again just before trial if it hasn't been settled by that point. And mediations, if you get the right mediator, can be very successful. So we have certain mediators that we always look for, that because they're so good, they're booked up for a long time because they get things done. It's no good to go to a mediator that doesn't, that's not going to be successful in getting the parties to come to an agreement. And what people have to realize when they're entering that, that mediation or just settlement in general, is it's all about compromise. Nobody comes out of a settlement, or rarely, I should say never, because like we just had one recently where it settled like lickety split, and they got, our client got pretty much everything what they were looking for. That's not that's not what happens all the time. So people have to realize is when they go into a mediation, or if they're going to settle early on, that it's going to involve compromise, because if the insurance company was going to pay you everything you were looking for, they would have done it in the first place. And so if you want a quick resolution, generally speaking, somebody's going to walk away. Everybody's going to walk away not with everything they wanted, but what they can live with, and might be happy with, but not everything that they were looking for. But having said that, a lot of times when people make claims, their claims are a certain amount that if they got a portion of it, a large portion of it, then they have enough to do all the repairs that they really need to get done. I forgot. We kind of glossed. Not we. I kind of glossed over it. But part of the discoveries phase is depositions, and that usually happens after the written discovery is done, because you want to have the answers to your interrogatories and your documents from the request to produce in hand before you start taking the depositions, because that's pretty much what you're going to use as evidence to ask questions of the deponents. And a deposition is, a lot of people, they don't really realize what they are. Like, they think that you're going to go in front of a judge, but a deposition is I wouldn't say it's an informal proceeding, but it's an out-of-court proceeding. In the days before COVID-19, it happened in a court reporter's office, and you go into like a conference room, and the only people that would be there is the attorneys for the parties and the person who is being deposed. That's the person who's is answering the questions, and a party's representative could be there as well. And you ask questions under oath. The court reporter's there to take it all down by stenograph. And it's kind of like testifying at trial. It's just you're not in front of a judge. So it's a little bit, it's less informal in that way, but it could be used at trial. It could be used in the case as evidence. So it's the same as testimony. It's just not testimony before a judge. And a lot of people get nervous about that, if they've never had a deposition taken before. But it's nothing really to worry about. An attorney will guide you through the process, prepare you ahead of time so you know what to expect, and go over everything about your case so that it's fresh in your mind. Because a lot of times when you take your deposition or you have your deposition taken, it's quite a long time after the events actually took place. So if you don't go over these things, you might think, oh yeah, that's a long time ago, I don't remember. So that's another aspect of the discovery process. And it's not just your deposition as plaintiffs that would be taken. Your attorney would take a deposition of people who are involved for the defendant, not just people who work for the defendant. Generally, in a property damage insurance case, the depositions we would take all the time is what's called the corporate representative, and that's just a person who's designated by the insurance company to speak on their behalf, because corporations can't speak for themselves. And someone who has specific knowledge of the case, such as the field adjuster, who is the person who goes out for the first time to take a look at the property on behalf of the insurance company and see if he can find out what the cause of the damages was, and if the insurance company is going to cover the damages and not deny the claim, then he'll write up an estimate. So we'll take a deposition of that person. If there's engineers, that sometimes the insurance company will hire an engineer if they deny a claim, and in that case we would take a deposition of the engineer. And it could be other people who are involved in a claim, and that's pretty much rounds out the discovery process. And that's, I have to say, when most cases will resolve. I mean, usually by the time you're done taking all those depositions, because a lot of time the insurance companies, they this is when they're getting prepared. Like a lot of times they're inundated with cases. If it's not right in front of them, and it's not in their mind right at that moment, it's kind of like out of sight, out of mind. But when you are taking these depositions, it kind of prods them to take a hard look at the claim and the case. And when they're doing that, they say, hey, I just reviewed this. We really should try to settle this because, we have some weaknesses here or what have you. And a lot of times like that'll be part of the impetus that gets a claim paid. If not, then you go on and continue the litigation. You might gather more discovery based upon the evidence that you collected in the depositions. You might do what's called a motion for summary judgment to settle certain issues of law that doesn't require a jury to weigh in on. There are different issues in the case. There are issues of fact and issues of law, and a jury has to decide the issues of fact, but a judge is the only one that will decide or can decide issues of law before a jury trial would ever happen. And that's the purpose of filing a motion for summary judgment. So a lot of times that case can be resolved by way of such a motion for summary judgment. There's other ways too, but that's a common way. Or you can knock out some of the defenses that are filed by the insurance company that they file along with their answer. And if that doesn't happen, then the next stage is preparing for trial, and getting prepared for that, and trial is about putting all your witnesses on that and all your evidence that you've gathered in discovery. It's like taking all those things that you've prepared for all this time, and narrowing it down what your strengths are in the case. Like, you might not take you might not call all the witnesses that you took depositions of, but the ones that were fruitful, and the evidence you gathered, which establishes your case. You gather all those things, and you go, towards trial, and you put on your case. Usually, that takes anywhere from 1 to 3 days, depending how complex the case is. And the jury will render a verdict either for or against you. And if you are unfortunate enough to have a verdict go against you, then there are fine attorneys like Ron Renzy who could help out and file appeal on your behalf if you think, or your attorneys think that the court got it wrong. Now, bear in mind, if a jury went against you and it was a judgment call, whether you should have won or lost, you might not want to appeal something like that. But if along the way the court got something wrong, and of course an experienced appellate attorney like Ron Renzy could tell you if that's the case, then you have the right to challenge the court's decision at trial. And actually, if you have something go against you during trial, like if somebody, the insurance company could also file a motion for summary judgment. It's not just the plaintiff that can file that. So if they won on summary judgment and didn't even go to trial, that's something that appellate attorney can help you with as well. But again, that those things are very rare in my experience. Most cases get settled, before they ever go to trial. So most people that would be listening to this would never even have to worry about that happenstance. But it's good to know that you have those rights if you should ever need to exercise them. And I think that pretty much goes through the litigation process.
I have a couple of
Okay.
questions that you brought up. Actually, you already answered one regarding the mediators and the use of certain mediators, which makes a good point because it's such a specialized area. It's good to have mediators that know these kind of cases to help you settle them. And along with that, I was wondering, since you cover such a big geographic area, but you focus on one kind of law on the property damage cases, do you come across a lot of the same defense counsel all the time?
Yes.
I mean, so you have a relationship with them, so does that help you resolve these cases?
It definitely can. It definitely can. When you have relationships with certain attorneys, and you have cases that are, it might not just be attorneys. For instance, I mentioned earlier. Well, actually, this wasn't during a broadcast, but before we went on, I was mentioning that Linda Knorr, the partner of the firm, is a member or a chair of the Federal Association of Insurance Reform, and she's also a member of FAPIA, which is Florida Association of Public Adjusters, something like that. And they have trade. I mean, before the COVID, we were supposed to have a conference, and they have these things all throughout the year, and they're attended by not only defense counsel but insurance company executives. And you when you're in the business as long as we have, especially Linda, you get to know these people and the players, and you can go to them in a case where they might not even be involved and say, hey Bob, I have a case involving your company or your firm. Is there something you could do to I've been trying to resolve it, and this new attorney who's on the case, who's only been admitted to the bar for 6 months. Is it possible that you could check in and see? You'd be surprised. Like it does help those connections you make with defense counsel, especially when you get along with them. It does help, and we've had resolved things by having good relationships with not only defense counsel and industry insurance industry people. Now, you're not going to get along with everybody. I mean, there are certain people and every first party property damage attorney knows them. There are certain defense attorneys who just it's their MO to try to make the the litigation process as difficult as possible, and you're not going to get anywhere with those people. You just know that that's the case. But for the people that you can have a relationship with, it definitely helps.
All right. So with that said, Joe, Ron talks about relationships with attorneys. Well, what about the relationships with the judges as well? I imagine that you've got to know certain ways that judge make decisions based on certain patterns or whatever in cases too. Because again, when we talk about familiarity, I wouldn't be surprised if you encounter these judges on more than one occasion, do you?
Yeah, the only thing is that a lot of the decisions that the judges make along the way are not make or break aspects of the case. Like, well, for instance, a lot of the hearings that we'll have along the way might be a motion to dismiss the complaint. Now, when a client hears, oh, there's a hearing on a motion to dismiss the complaint, they're like, oh no. All that means, I mean, the judge is not going to throw out your case. All that means is that the insurance company is saying, hey, they didn't allege things the way I think that they should have alleged them. You need to make them do it the way I want you to do it. And a lot of judges will say, nope, sorry, they did it the right way. I'm going to deny your motion. Or, okay, I'll make them tell you a little bit more information, add some more facts or something. It's not a big deal. And courts are very generous with giving parties the ability to amend their pleadings. So if something isn't to the court's liking the first time, you'll definitely get it right. So in other hearings that are common are, we ask for discovery from the insurance company. They might object to certain things, and we'll go and litigate over those objections. And I tell you, there's nothing the court hates more, a judge hates more than having to preside over those types of things, because they just see it as two attorneys squawking at each other. I asked for this, and he won't give it to me, but he doesn't deserve this. Like that's how you could just see them throwing their, like, I can't believe they're actually coming in front of me with this. And again, like, there's nothing huge that are going to make or break your case that's going to happen from a hearing like that. But these are things that you experience along the way. That yes, you know what certain judges are going to rule ahead of time at these hearings. But your case is really not about that so much, but about the overall. And the judge has to follow the law. The judge, can have his own. Like, there's a lot of judges that can disagree with on certain things, which is fine. But the really important stuff is they're going to have to follow the case law precedent, and that's kind of Ron's specialty. If they don't do that, then they can be reversed on appeal. If there's in the court system, you have the courts that we're in front of called the trial courts, and then you have the appellate courts, and there's various stages of the appellate courts, obviously going all the way up to the Supreme Court of Florida. But there's the district courts of appeal, which if you have a claim that's over $30,000 and you want to appeal it, it would go to that. If you have a claim for under $30,000 and you want to appeal it, it goes to the appellate division of the circuit court, which are the each county has. So yeah, I mean, it's good to have a rapport with these judges, and obviously the more you see them. But the key is really just, those judges, they're going to make decisions based upon, what they think is right and following the law. I mean, they're not, knowing them might help, because you'll probably have the benefit of the doubt that you're a straight shooter with them. And you definitely want to have a reputation of being a straight shooter and not being someone who tries to pull a fast one and misrepresent things. So I mean, if you have that, then it always helps. But I've been in front of judges who I think are great judges, who on one day they'll rule for me, and the next day they'll rule against me. And that's all you can expect is that they're going to be they're going to follow the law and be consistent. No one hates what everybody hates more than anything else is a judge that just shoots from the hip, just wakes up one morning, say right by on the bed and just issues an off the wall ruling. And I think every attorney's been in front of a judge like that in the past, where I don't care if I get overruled. This is the way I'm going to rule, and whether it comports with the law. I don't care. I mean, there's not many judges that do that, but I've been in front of one or two in my career that's like that. That's even when they're ruling for me, I gotta shake my head and that's not the way this should be.
Now, let me use a baseball analogy, if I may. Okay, and for a lot of you sports fans out there, I believe if I'm taking in what you're saying to be correct, Joe, when you have an umpire, you don't care if the strike zone is high, just be consistent with it.
Yes.
If it's low, be consistent with it. If it's a generous one, but don't go out there and make sure you're inconsistent. That way nobody knows what to expect. And if I'm hearing this correctly, I have a feeling that's exactly what you're referring to.
Yeah, somewhat. I was actually thinking that as I was saying it, with the caveat being that they still have to follow the law. I mean, they can't consistently not follow the law. I mean, they'll get overturned, by attorneys like Ron Renzy will take them up on appeal and get them overturned. And no judge wants to have the higher court come back and say, you got it wrong over and over and over again. So, but I think, most judges want to get it right too. And most judges I'm in front of, if they don't know an area of the law that well, they want the attorneys that are in front of them to educate them on it. And if sometimes they're new to a division because they get transferred from a criminal division to a civil division or vice versa, so they might not be as adept at the legal arguments that the attorneys that are in front of them are. It might take them a little time to get up to speed on some of these issues, but eventually they get there, and then they try to do their best to but not, like some judges have, some umpires have different strike zones. Some judges, there's certain issues that come up in every case that we file, and it's not the type of issue that's gone in front of an appellate court, because once an issue goes in front of an appellate court, especially the Supreme Court, but if it's decided by the appellate court in the district that you're in, that solves everything. That when that court renders an opinion on that in an appeal, that's the law of the land, at least for that area of the state. Sometimes this is annoying, but you'll have conflicting opinions by different district courts of appeal throughout the state, and what you're governed by is the district court in your area. If there's only one district court that's entered, who has entered an opinion on it, then you have to follow that one. But if no one has, it's kind of like the Wild West. And I have this certain issue that, depending on, I've gone in front of countless judges, and they all do something different. And even in the same courthouse, they'll say, my colleague Judge so-and-so rules this way, and I respect him for that. I understand the decision, but I rule this way on this. And you sometimes what's going to happen before you go there, but you have to advocate on behalf of your client. So you can't give up your client's rights. So,
Joe, I actually had a question, which I think during the first broadcast last week, we talked a little bit about, since property damage is a little bit different than other areas as far as fee structure, if you have to file suit. Can you explain that a little bit?
Yes. So once you file suit, and I think I touched on it a little bit last week, that before filing suit, this doesn't apply, but after you file suit, it does. Florida statute 627428 governs attorney's fees in insurance matters. It's a one-way street, meaning that if a insured is successful in obtaining a recovery against their insurance company, then they're entitled to get their attorney's fees. So, and this doesn't apply to the insurance company. If you lose, the insurance company doesn't get it. Now, the insurance company is trying very hard to get rid of these statutes. So if you see this happening, you might want to write a letter to your local government, because the insurance company has a very strong lobby and they don't want to have to pay out any more money than they have to. But they're huge companies that have endless resources, and the average homeowner doesn't have these endless resources. So the purpose of these laws is to kind of even the playing field, so that if the insurance company does shortchange you, or they deny your claim, or they underpay your claim, you can file a lawsuit without having to fear that if you lose, you're going to have to pay thousands of dollars in attorney's fees to your attorney, if you're not successful. Or even if you are successful, you have to have that deducted from the amount that you get. So 627 Florida Statute 627428 provides for those fees if you get a recovery, and it's not just going to trial. If the insurance company settles your case while the case is ongoing, you have the right to collect that as well. So that is the reason why we are able to do these cases on a contingency fee basis, or part of the reason, because it's one thing, like if you have a personal injury matter, if your claim is worth $500,000, you're not going to have a problem with having a personal injury attorney take your case. But if your case is for $10,000, they say, well, look, there's no doubt that you were injured. There's no doubt that there's liability, but your damages are just not enough to take the case, because if we take a third of your recovery, that's only a few $1,000s. That's not going to cover much litigation. So in personal injury, your claim has to be worth enough for an attorney to take it. The good thing about property damage is you don't really have to have a huge claim for it to make sense to file a lawsuit, because your fees will get paid. So if you only have a $15,000, $20,000 claim, you can still hire an attorney, and the attorney will still be interested in taking your case because of that fee statute.
Interesting point. All right, I have a question for you, Joe. Let's just say hypothetically, a case does get appealed and Ron is able to get it overturned. Do you think that counts as a mark against the judge for it to have been overturned? I know sometimes, reputations can be, I don't know if they're vastly affected, but you know where I'm going with, where if you have too many things that are appealed, it goes against you because, obviously the law wasn't interpreted the way one would have thought, and then Ron does what he has to do. You know where I'm going with this?
Yeah, I mean, Ron might be better equipped to answer that question than me. Okay. Although in my past, when I did personal injury protection claims, and I also did appeals back then. I mean, it really depends on the judge. I mean, I've had plenty of judges say to me that, look, I could be wrong, and if I am, I won't take any offense if you appeal this. Right. It really depends. It really depends on the judge, but you have to do what you have to do. I mean, you can't not file an appeal because you might hurt the judge's feelings. They might hold it against.
That's a very good point.
But I don't think most judges. I can't think of any judges that would do that, and plenty of judges that I know would say, if I'm wrong, I'm wrong. I'll stand corrected. But they want to get it right. They don't want to get it wrong.
Right.
They want to get it right. There's no doubt about that. I agree. No doubt about that. Joe, I had a question. You said that you do a lot of mediations, in your cases.
Yeah.
How long do mediations, like an average, just so people understand, an average mediation, how long would it last?
All right. Expect to be there all day.
Okay.
Should they last all day? No. You could bang a mediation out in an hour. You should be able to. But the insurance company, this is the standard MO of an insurance company going to mediation. Your claim is worth $200,000. They come into the mediation. We'll offer you $5,000 inclusive of your attorney's fees. When you've been, when your legitimate losses are in the hundreds of thousands of dollars, and your attorney's fees are in the tens of thousands of dollars at least. But that's I really believe that most insurance companies, their MO is just to start out with the lowest possible number and then just drag out the process as long as possible, and then wait for hours and hours to go by to break down the plaintiffs, the insureds, and then only offer some real money later on. Now, is that how all of them go? No, but I've rarely been to a mediation that hasn't lasted several hours, unless it's an impasse. I've been to some where they just say, we're not going to pay you anything, or this is it, take it or leave it, and it's a very small amount, and it ends very quickly. That's not common either. But in my experience, a mediation that shouldn't take that long could last hours and hours and hours.
All day.
And like I was at one where, we were at an amount that was high, and then the insurance company came down low, and and they would like dole out the increments, like, okay, we'll go from 5,000 to 6,000 or to 7,500, and then all of a sudden, after we were there for like maybe 4 or 5 hours, they go from like $10,000 and jump up to like $70,000, like just like that. And I'm like, you couldn't have done this like 4 hours ago. Like you had to like sit on the small numbers all this time. And what happens is, and it really depends on the mediator. So some of them are very, very talkative. I've been in front of some that like, I'll be just like, please, just convey the offer. Like they'll just like want to chit chat. They're getting paid by the hour. And, we've known not to use certain ones that have done that in the past, and focus on the ones that are really, have been successful in getting the parties to get together. And usually the ones that are able to do that are the ones who could tell it like it is. They have the experience and say, look, I've read over the policy. I've read over their, your complaint and the answer and all the defenses. This is what I think is going to happen, and the parties take that to heart. And sometimes that goes against your client, like sometimes they just have a bad policy or they have bad facts, and sometimes it goes in your favor. Sometimes, you'll get almost everything that you're looking for, because the insurance company realizes their defenses aren't really all that good, and they need to cut their losses and come to an agreement. So, a good mediator will get the parties to realize that and come to an agreement. Whereas the not so good ones will just like, oh, okay, we have an impasse.
Well, and mediation is such a helpful thing. I agree with you. I was wondering, in your experience dealing with property damage claims, do you find the best mediators are former plaintiffs' lawyers, defense lawyers, judges, or they just come from all walks of law?
It really depends on the personality. I would have thought that judges, former judges, just would have been, just because they could say, hey, look, I've done this for years, and this is how I would rule. But not all judges do that, and I've had some mediations with judges who weren't that effective, and I'm not going to name any names, but the one that we use, or we like to use now, is an attorney, not a judge. I mean, he's he does a lot of mediations, but he's I don't think he's ever been a judge. It's just he just has a very his presence, his he just has a very commanding presence, and he brings the sides together and is able to I don't know. I don't think I've ever been to a mediation with that particular mediator where we haven't settled, whereas many other ones that we haven't. And, because of that, like a lot of times we can't use this particular mediator just because it takes months. Like, other ones we can get booked within a short amount of time, like within 30 days. This particular mediator might be 2-3 months out. And then, like, you have to take a certain time slot, like 5:00 p.m., and nobody wants to start a mediation at 5:00 p.m. So,
No.
So getting the right mediator can really help. Now, it's not like he's the be all and end all. I mean, we have other mediators that we use that are very good and that we've had success in front as well. So it's not so much that, like, but you definitely don't want to go in front of a mediator who's not a very good mediator, because that'll be just a waste of time.
All right, so let me go back to Ron for a moment. We have another 5 to 7 minutes left to go in the broadcast. So with that said, Ron, I mentioned this about judges and their reputation. So you say that for the most part, they don't really worry about their reputation at all. You have to be kind of thick-skinned in this business. Or do they really worry about it?
Right. Well, I would say judges want to do the right thing. Like lawyers want to do the right thing. They want to apply the law to the facts they have,
Right.
and which is a really not an easy thing. I mean, it's a very difficult thing. So I got to give judges a lot of credit to be able to do that. I mean, like, you take a set of facts, even when, let's say a client comes to Joe and say, this is what happened to my house. I mean, it's not like you just go to court and say, my client says this is what happened to their house. There's a lot more that goes into it, a lot of investigation that has to be done. And Joe, feel free to pipe in here. There's a lot of legwork that has to be done to put a case together. Isn't that true?
Yeah, definitely. So, yeah, I mean, let's put it this way. I would never, it would never be something that I would think about to offend a judge by anything that I fought, I mean, unless you're filing this like a frivolous appeal or you're filing a motion to disqualify the judge because you didn't like a ruling or something like that. I mean, if it's frivolous, you might want to not do that because you're going to have to be in front of that judge again. But if it's well taken, I mean, you do what you have to do. But I can't think of any judge that I've been in front of that would have their feelings hurt.
I agree. We have some excellent judges. We really have some excellent judges around in the area. There's no doubt about that. It's case is complicated, and I think Joe would agree. Sometimes your own client is not very realistic on what maybe the claim is worth, and that's where Joe comes in and explains from all this experience that this is what happened, this is what's going to cost. It's not a and I know people want to be compensated, but it's not a windfall. Is that a good way to say it, Joe? You're not going to.
You're definitely let's put it this way: you go down the highway and you see these billboards that so and so got me, $1.3 million.
Right.
You're not. This is not your payday. You're cha-ching. You're going to get an amount of money that hopefully is going to allow you to rebuild your property, repair your property to its pre-loss condition. Now, sometimes this is not an uncommon scenario. Sometimes we'll have a client whose roof was already 23 years old at the time of the loss, and the insurance company is saying, "Hey, look, this is wear and tear. This is not from the damage from the storm, even though the leaks only took place afterwards." Now, I don't know about you, but if I had a roof that was 23 years old and I got the insurance company to pay for a brand new roof, I didn't have to pay anything out of pocket, I would feel like I won the lottery. Now, that generally doesn't happen. So when these cases settle, a lot of times it's a compromise. They'll pay some amount, but it's not the full amount. And I think a realistic homeowner will realize in a scenario like that, if they get the insurance company to pay a chunk of that, cost for a new roof, then they're ahead of the game. Now, contrast this with some of the clients that we've had in Panama City, where their roof was 1 year old and the hurricane tore it off. Yeah, that's a case where you're not going to compromise. If the if it was a legitimate loss, no doubt about it, there's no dispute. In most of those cases, the insurance company's not even denying the claim. They're just saying, okay, your estimate to re-roof your house, which is $75,000, is more than we think it's reasonable. We think you could do it for half that. Then, there might be some wiggle room
Right.
there. And that actually brings up another scenario, which is not, which is specific to these types of claims. And I don't think I brought it up at the last podcast, but there is a provision in most, if not all, insurance policies that allows for an appraisal. And this could be, some policies require both parties to agree to it. Some only require one party to ask for it, and this can be done before or after litigation starts. And this could be a way of getting your claim resolved either before litigation or after litigation. Sometimes we'll file suit, and the insurance company will say, "Hey, we want to invoke the appraisal process." And what the appraisal process is, the insurance company picks some sort of professional, contractor or an adjuster to go and assess what they think that the damages are and the cost to repair, et cetera, and give a number. And then the plaintiff would do the same thing. A lot of times it's a public adjuster, but it doesn't have to be. And if they can agree upon an amount of the loss, then that's it. But generally speaking, it goes to what's called an umpire. Umpire takes a look at what both sides appraisers value the loss at, and they make a decision. And whatever that decision is the amount of the loss. And that's a different way that these things could shake out. It's not common. I mean, when I say it's not common, it does happen. It doesn't happen in all cases, but a small percentage of cases, that's how these things get worked out. And that's just something that's just another one of the things that you should be cognizant about, your insurance policies, because most people don't know what's in their insurance policy. There are things in a policy, I think I was alluded to last week, where some insurance companies give themselves the right to fix the damage in your property.
All right, so as we put a button on this broadcast, okay, let's do it this way. Are there any things, Joe, that you want to bring up in the next couple of minutes to summarize what people should be looking for in the second part of our series tonight?
Well, I mean, with this, this was just an explanation of the litigation process. Again, this is only going to tell you about what happens once all of your efforts to resolve your claim with your insurance company have failed, or if you've hired a public adjuster, if their attempts have failed. And of course, a public adjuster they act as your agent or your with the insurance company, so they can't bring about litigation themselves. So there's only so far that you can go or they can go. And then if things totally break down and you're just at an impasse with your insurance company, the only thing that you have left to do is to file a lawsuit against them. And that's where a firm like the Norlaw Group can help you. And, what we went over today was basically what to expect in that litigation process. And the one thing I could say is, if you're going to get into it, then, don't get into it lightly. I mean, it's not going to be a process that happens overnight. If it's not for everybody. Some people just are adverse to this type of thing. So, if you don't think that you can handle having your deposition taken or going in front of a judge, which is very unlikely, but could happen. Some people aren't like that, then maybe it's not for you. But for the vast majority of people, it's not a difficult process. It could be a lengthy process. So be geared towards this taking some time to come to a conclusion. But otherwise, an average litigant doesn't have to be that involved. We keep them up to date in what's going on and tell them what's happening at hearings or whatnot. But on a day-to-day basis, a litigant really doesn't really have any hands-on with their case, and only needs to be really involved when their deposition's being taken or if discovery needs to be answered, and I have to to talk to them what their answers are for interrogatories or request to produce, things like that, or mediation. But so I mean, generally speaking, it's a pretty painless experience and something that could feel daunting, but it's really not, and can be very worthwhile. We're very successful in obtaining a positive result for our clients and getting them money that they wouldn't have otherwise been able to recover if they hadn't chose to file suit against their insurance company.
Very good. Okay. Well, we have to look forward to next week's edition of the South Florida Tribune podcast. We're going to bring in a mold and restoration specialist. So hopefully you can join us there. With that said, Ron Renzy, why don't you let everybody know how they can get a hold of you, what you specialize in, and then Joe will follow suit, and then I'll go over the particulars, how you can follow us on these broadcasts and talk about some of the other shows as well. Ron, lead it off.
Thank you very much. My firm is Wahlberg and Renzy. We handle Florida appeals and litigation support. Our number is 954-757-1212. You can reach us at info@wahlberg-renzy.com or follow us on social media.
Joe, go ahead.
And again, I'm Joe from the Nor Law Group. We can be reached at 954-749-3151. Although during the pandemic, we're working remotely, but we're fully functioning. So you can reach me on my cell phone, which is 954-362-0580. We're online at claimhelplawyers.com. And you can also find us on Facebook and follow us on Instagram. And consultations are free. So so you have nothing to lose by giving us a call.
All right, and as for we're concerned, I know a lot of lawyers nowadays or attorneys are working remotely due to COVID-19. I get that. And I have a feeling that may not change for quite a while, but we'll see, TBD on that. But that said, you are watching and listening to the South Florida Tribune podcast. My name is Scott Morganroth, the Motor City Badmouth. My co-host tonight are Ron Renzy, the guy with the beard, and Joe Littman, the guy with the tie. Okay. And if you want to listen to the audio version, you can do so on Apple Podcasts, Spreaker, Spotify, iHeartRadio, Google Podcasts, or wherever you get your podcast. Again, Apple Podcasts, Spreaker, Spotify, iHeartRadio, Google Podcasts, or wherever you get your podcasts. Also, you can follow us on social media, Twitter at Tribune South. That's at Tribune South. You can also follow us on Facebook and Instagram by going to the South Florida Tribune, like us, and you'll be able to get the most updates there. Here, the YouTube channel, this is it. You can find all of our broadcasts on that. To the South Florida Tribune, we encourage you to subscribe to let you know what you get for your value. To subscribe with the YouTube channel, which is what we're on now. We have a bunch of other shows as well. Our top sports show is the Sports Exchange. No Limits follows us tonight. Andy Abley and I co-host this broadcast once a week, and every now and then we bring in some guests. 108 Stitches Baseball Talk, we give you the latest updates in the Diamond doings, and I'll tell you what, this is a show that we certainly enjoy doing. The Great American Pastime is alive and well with us. The Real and the Rare comes on a couple times a month with my young guy, Xavier McKnight, does a really phenomenal job. And of course, we do a fantasy football broadcast as well. And yes, you guessed it, folks, you are looking and listening to the South Florida Tribune. So Ron, Joe, pleasure to have you on. I should also point out that Ron and Joe and myself, we belong to the Coral Springs Regional Chamber of Commerce, and we're proud to be in the Wednesday referral group as well that meets at City Hall during normal times, and we do it remotely a couple times a month. So we look forward to bringing more and more people not only from the chamber, but if you have any suggestions, feel free to do so. If you want to go ahead and a few other things worth noting, please go to our website at www.southfloridatribune.com. You'll find all the broadcasts over there, lots of content from our writers as well as our media distribution partners. And we also have a Motor City section for folks in my hometown where we keep tabs on a lot of developments back in my home state as well. You can email me at southfloridatribune@gmail.com. And if you want to contact me through LinkedIn, Scott Morgenroth gets it done. It's not Morgan where you'll probably find a million of them, but Scott Morgenroth is there. I can't remember how many of those are really duplicated, but you're less likely to find Scott. You'll most likely find Scott Morgenroth on LinkedIn. All right, glad I got that right. So with that said, been a great broadcast with the three amigos here. Ron Renzy, Joe Littman, myself, Scott Morgenroth, the Motor City Madmouth. All I ask everybody to do out there is please be safe and take COVID-19 seriously. We don't have a vaccine at all. And for those of you that don't mask up, shame, 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 as Gomer Pyle would say, and we're all old enough to say, shame, shame, shame. So once again, on behalf of my co-host, this is Scott Morgenroth, the Motor City Madmouth. Thank you for joining us on this edition of the South Florida Tribune podcast. Good night. Be safe.
Thank you, Scott. Thank you, Ron.
Good night.